Ambassador of Republic of Indonesia to Canada, and Director General for Asia Pacific and African Affairs Ministry or Foreign Affairs of the Republic of Indonesia. Second, Professor Dr. Edi Pratomo SHMA as former Ambassador of Republic of Indonesia to Federal Republic of Germany and Dean Faculty of Law, Universitas Pancasila, Indonesia. Third, Professor Dr. Jus Stefankus from BINUS University, Munich, German, as visiting professor as Business Law Department, BINUS University, Indonesia. And also we would like to say welcome to the Honorable Mr. Dr. Ahmad Sudiro SHMH, MMMKN, as Dean of Faculty of Law, Universitas Tarumanagara, along with the staffs. The Deans of Consortium members from Universitas Pancasila, BINUS University, Universitas Esa Unggul, Universitas Kristen Indonesia, Universitas Muhammadiyah Jakarta, Universitas Pelita Harapan, and Universitas Trisakti. Ms. Vera Weni Esumarwi, SHLLM, as Lecturer of Faculty of Law, Universitas Tarumanagara, who will be the moderator of today's webinar. And last but not least, for all the guests who have the opportunity to virtually attend this event today. On this special day, we will have the international webinar, which will be divided into 3 sections, which the first section will be delivered by His Excellency Ambassador Abdul Qadir Jailani SHMH-MA. The second section will be SHMA, and the third section will be delivered by Professor Dr. Jus Stefankus from BINUS University, Munich, German. And after that, there will be question and answer session, and followed by conclusion from the moderator. So ladies and gentlemen, before I invite Ms. Vera to the virtual stage, allow me to inform you a little bit about our moderator today. So this beautiful and smart lady's full name is Vera Weni Esumarwi SHLLM. In 2000, she graduated from Faculty of Law, Universitas Trisakti, and then she continued her study in Leiden University, Leiden, the Netherlands, and graduated from with master degree in Public International Law, LLM, in 2011. And from 2014 until now, she is a lecturer at Faculty of Law, Universitas Tarumanagara. So ladies and gentlemen, without any further ado, I invite Ms. Vera as our moderator today to take over the virtual stage, and then the floor is yours.
Thank you, Mr. Nabila. Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera bagi kita semua. Good morning, our distinguished participants. Your Excellency, Head of National Legal Development Agency, Professor Widodo Eka Cahyana. Your Excellency, Head of Higher Education Service Institute Region 3 Jakarta, Professor Dr. Agus Setyobudi. Your Excellency, Rector of Universitas Tarumanagara, Professor Dr. Insinyur Agustinus Purna Irawan, Rector of Universitas Pancasila, Professor Dr. Edi Tut Hendratno, our distinguished speakers, Your Excellency, Mr. Abdul Qadir Jailani, Professor Dr. Edi Pratomo, as well as Professor Dr. Stephen Kus, our distinguished and decent professors, bureaucrats, researchers, lecturers, and students. Today we are gathering at the international seminars of facing the challenge and opportunity of the legal discipline and profession for the next decade. The development of technology has influenced various activities in human life globally. Does it impact on handling human trafficking in Indonesia? Indeed, there are many pros, cons, opportunities, and challenges utilizing the technology in all aspects of human life, including regulating national and international law. How we have to take advantage of the development of technology information? To answer that question, we will learn from our decent speakers. I briefly read the curriculum vitae of the speakers. However, the committee will present a complete CV. This webinar cannot be broadcast live on YouTube, but viewers who need recordings can download it on the Law Faculty of Universitas Tarumanagara's YouTube account. All presentation material will be delivered by the committee via a link that will be shared in written. Your Excellency Ambassador Mr. Abdul Qadir Jailani, Currently, he holds position as a Director General for Asia Pacific and Africa at the Ministry of Foreign Affairs of the Republic of Indonesia. From 2019 until 2020, he was the ambassador of the Republic of Indonesia to Canada and permanent representative of the Republic of Indonesia to the International Civil Aviation Organization based in Ottawa. From 2016 until 2019, Ambassador Jailani served as the Consul General of the Republic of Indonesia in New York. His other past assignments in the Indonesian Mission Board include Counselor for the Security Council at the permanent missions of the Republic of Indonesia to the United Nations in New York and other international organizations. He graduated with a bachelor's degree in law from the University of Erlangen 1992 and hold a Master of Law from the University of Indonesia 1997, as well as a Master of European Law Policy from the University Portsmouth 2002. We will learn from the second speaker, Your Excellency Ambassador Professor Dr. Edi Pratomo, short introduction of his CV. From 2019 until 2013, he was a former ambassador of Republic Indonesia to the Federal Republic of Germany. Current position Professor Dr. Edi Pratomo as Dean of the Faculty of Law, Universitas Pancasila, Chairman of Publication Consortium for Legal Study. Moreover, the third speaker is Professor Dr. Jur Steven Kuss, Professor at Universität der Bundeswehr, Munich, Germany. From 1986 until 1991, study of law and of political science at Universität Würzburg, Germany. 1994, second state examination in Munich. From 1994 to 1995, judge at District Court Strotoda, the state of Truminia, in civil law, agriculture law, criminal law, and guardianship law. 1996, doctorate in law at the Law Faculty of the University Constantine. Postdoctorate qualification at the University of Constantine 2002. Venia Legendi, authority to teach in civil law, corporation law, competition law, and international private law. From 2010 until 2012, Dean of the Faculty Economic and Organization Science. Since 2011 until now, he is a visiting professor at several law faculties in Indonesia and also visiting professor at BINUS Jakarta. Professor Kuss has published many publications in national and international journals. The presentation time is given to each speaker no more than 20 minutes. I will remind all decent speakers when the time allocation has ended. Please allow me to remind you. I invite the first speaker to deliver your presentation, Your Excellency Ambassador Abdul Qadir Jailani. The time is yours, Ambassador Jailani.
Thank you, Ibu Vera, for your kind words and introduction. Good morning, everybody. I'm very glad to meet you all in this opportunity, particularly to Ambassador Edi Pratomo, my mentor, and Professor Kuss to have discussion on a question which is pertinent in the current international politics, that is the issue of trafficking in persons, that I intentionally choose this topic since this is a very important issue. Today, my presentation will focus on some diplomatic efforts pursued. Just a moment. Whether my screen, okay, that's good. Okay, my presentation will focus on some diplomatic efforts pursued by Indonesia at various levels in countering trafficking in persons. To start with, I think, can you go to the next slide, please? No, not the first one. Okay, no, after that, sorry. Okay, good. To start with, I would like to talk a little bit about the definition of trafficking in persons, since the concept is pretty technical, that specific understanding is required. Speaking of the definition, we need to look at the Protocol on Trafficking in Persons, to which Indonesia is a state party. According to the protocol, the definition at least has 3 elements. The first element is trafficking must consist of series of acts that include the recruitment, transportation, harboring, or receipt of persons. Second, such act of trafficking must be perfected by means of threat of or use of force, deception, coercion, abuse of power, or position of vulnerability. The third, the intent of the act is always exploitation. The similar definition is also used in our law number 21 persons as our national implementing legislation of the protocol. After discussing the definition, in the next slide, I wish to discuss our interest in consolidating international cooperation for coping with the challenges of trafficking in persons. Trafficking is essentially a crime that absolutely undermines human dignity, and indeed is in contravention with human rights values. So I would say that is a groundful moral justification to pursue diplomatic efforts in combating the crime. Human trafficking occurs in every region of the world. States can be the origin, transit, or destination country for victims, or even a combination of all. It has been increasingly widespread by transnational crime groups. For this reason, states need to act together to confront this new threat. Human trafficking constitutes non-traditional security threats that requires new approach to address it. And therefore, there is a need to adopt a strategy for global collaboration to prevent and combat human trafficking. In the next slide, I will to discuss a little bit the levels of diplomacy that Indonesia has embarked on. The conduct of such diplomacy has been carried out in various levels. At the highest level is at the multilateral level, which provides a global framework for all countries to work together. Such multilateral level is also complemented by regional framework. Last but not least, diplomacy at bilateral level is always necessary to reinforce international and regional cooperation in the area. In the next slide, I wish to elaborate the diplomacy at multilateral level. As we know, international community successfully concluded a UN Convention on Transnational and Organized Crime in 2000. The convention has been also known as Palermo Convention. It was adopted together with a protocol to prevent and combating. The protocol also aims at protecting and assisting victims of such trafficking. It includes a legal obligation on criminalization of trafficking in every state party to the protocol. The protocol also set a new international benchmark for national measures that need to be taken by relevant state parties. More importantly, the protocol should also serve a legal basis for states for conducting cooperation in the area of extradition and mutual legal assistance. The next slide is about regional framework for diplomacy related with human trafficking. With the growing issue of human trafficking within and involving the ASEAN countries, ASEAN eventually concluded the ASEAN Convention on Trafficking in Person in 2015. The content of the convention is essentially reiteration of the ASEAN countries' commitment to Palermo Convention and its protocol. Not only that, the convention provides more detailed and robust provision for regional cooperation. It also recognizes the need for more coordinated enforcement and collaborative excellence across the region in order to better prevent trafficking and protect and assist victims. Another regional framework is Bali process that I will discuss briefly. In 2002, Indonesia and Australia took the initiative to establish a regional mechanism which is called as a Bali process on people smuggling, trafficking person, and related transnational crimes. And I believe Ambassador Edi Pratomo will discuss this issue a little bit further. I just want to share with you that this process is a voluntary and non-binding regional consultative process chaired by Indonesia and Australia and comprising 449 members, including UNHCR, IOM, UNODC, and ILO. The focus of the cooperation is a capacity building and information sharing. Bali process has shown its success story in consolidating regional cooperation on how to develop practical initiatives to address people smuggling, trafficking in person, and related transnational crime under bilateral framework. Bilateral cooperation is also paramount important. Indonesia has concluded a various bilateral arrangement with many countries, including Vietnam, Canada, Australia, and some others. This bilateral cooperation is essentially a follow-up of further operationalization of cooperation under multilateral or regional framework. The basic element of these bilateral cooperations are, in most cases, include capacity building, exchange of information, mutual assistance, and jointly coordinated policy force and activities. Now we are arriving at an issue which is also important. It is about preventive measures. The protocol clearly mentioned the obligation of states to establish comprehensive policies and programs with respect to the prevention of human trafficking. The root causes of trafficking are various and often diverse from one country to another. Trafficking is a complex phenomenon that is typically driven by social, economic, cultural, and other factors. But there is one cause that tends to be common to trafficking in general. That is the desire of potential victims to migrate to other countries. Some of the common factors are local conditions that make population want to migrate, such as poverty, oppression, lack of human rights, lack of social or economic opportunities, dangers from conflict or instability, and other similar conditions. Therefore, countries need to undertake measures such as social and economic initiatives targeting potential victims. Raising awareness is also essential. Countries need to develop information campaign for general public on the dangers associated with trafficking. It should specifically address the problems related to the potential victims' decision to migrate. Discouraging demand is also inevitable. Demand is usually associated with the need for a particular labor or services, but in the context of human trafficking, state should suppress the demand that foster all forms of exploitation of persons that leads to human trafficking. Destination state should examine the factors that make them attractive for human trafficking in a faceted way. In this context, Indonesia needs to establish bilateral cooperation in coping with this challenge. My last slide is about safe migration. It deserves to be discussed, as we know that irregular migration may contribute to the increasing cases of human trafficking. In this regard, I would like to mention the Global Compact for Safe, Orderly, and Regular Migration, or we call it GCM, adopted in 2018. It is the first non-binding framework for international migration governance. It should serve as a set of guiding principles in the promotion and protection of the rights of migrants. It provides guidance for states to empower migrants to contribute positively to economic development and reduce the push factor of irregular migration. GCM contains various objectives that are pertinent to global efforts in prevention trafficking. Against this backdrop, countries are required to promote the implementation of the global plan of action to combat trafficking in persons. Next slide is, I think, I'm arriving at the end of my presentation, but before I conclude it, I wish to reiterate that Indonesia shares the great interest in promoting international cooperation against trafficking persons. To this end, our diplomacy has been carried out at various levels, multilateral, regional, and bilateral level, as I mentioned earlier. Our diplomacy also tackles the need to cooperate in the area of prevention. In this regard, the effective implementation of Global Compact for Safe, Orderly, and Regular Migration is important, as it contains various objectives that are relevant to global efforts in prevention trafficking. I thank you, Bu Vera.
Bu Vera, I think you still mute your microphone. Yeah.
I'm sorry. Yeah, I'm thankful for your fruitful information, Ambassador Abdul Qadir Jailani. And then the next speaker, I invite Your Excellency Ambassador Professor Dr. Edi Pratomo to deliver your presentation. Professor Edi will present two material presentations. Professor Eddie, please pay attention to the time allocation for.
Thank you, Mbak Vera, for giving this opportunity. I would also like to say hello to the speakers, His Excellency Ambassador Pak Kadir Jailani, several distinguished participants from different universities in Jakarta within the LLDIKTI III. It is very fortunate for me to become a speaker after Pak Kadir. I have nothing less to discuss, in fact, on the people smuggling, because he has already given us a comprehensive overview on the root causes, on the diplomacy from bilateral to multilateral, and some recommendation that has been made by His Excellency Pak Kadir. I would, of course, try to now relate between the development of international law or law science, especially with certain issues of the international law at the national or international level. As our bigger topic is the future of law, especially facing the new challenges and opportunities ahead for the law discipline and law professionals. And how does it relate to the people smuggling and other transnational organized crime issues, which are very much relevant to be discussed at this very forum. Number one, I would like to go to slide page 3 of the paradigm shift. Talking about the new challenges of this very changing world that's so fast, I think we need now to be more wise and soon to adopt our new paradigm mindset compared to the old paradigm. We discussed before study to the highest degree only. And now, under the new paradigm, we need to have a lifelong education system. The other one, which is very important, is that we were using a classroom learning process. But during this pandemic time and the development of information technology, I think we need to be familiarized with the learning online system by virtual, by Zooming, by other many applications from anywhere, somewhere and anytime. So we need to change our new paradigm on how to deal with the law professions in the next decade. Before we have an institutional centered learning process, and now we have to change very quickly to be based on the market centered process. Technology as a burden before last time, but now we are developing a technology as a reinforcement at the era of pandemic. So we learn more and more about the advantages of having a new high technology. Second, number one is new paradigm in order to respond to the new challenges. I would suggest that number two, we need to redesign our law curriculum so that it will in line with the industrial revolution, with the 4.0 or 5.0. I have at least 5 elements on this very topic. Number one is that law professions, we need also the linkages between interdisciplinary and transdisciplinary approach. We could not study on the law, but we have also to study and to strengthen our capacity to learn other related issues, including economy, politics, and other issues which are relevant to the development of legal studies. We have also to have a collaboration between national law and international law, because international law is also become our national law. In a globalized world, we have to accommodate the concerns and the development of international law within our national legal system in Indonesia. We have been having many experience to deal with these interdomestic relations, international and domestic relations. The third one is the information technology based. Although in the future, there will be serious threat and implication about the difficulty in our legal professions, but it should be realized that technology is, if mastered, we will have the learning process smoothly. The next is country and world interests. Indonesia is a maritime country and the largest archipelagic country in the world. So we need to educate our mahasiswa, our students, to know more about the archipelagic state regime of Indonesia, because 2/3 of our territory is consisting of oceans. The rest are land. So we need to master the law of the sea for the law students in the next decade. And with regard to profession introduction, I have tried 2 weeks ago to initiate a program of knowing the diplomatic professional teaching, how to become a diplomat of the Republic of Indonesia. I was trying to introduce the professions of diplomatic persons and how to enter that school of diplomacy. How do we prepare students to become, to have another opportunity for the legal profession. With these situations at the national and international level, there are many challenges, as have been mentioned by Excellency Director General Kadir, on people smuggling, trafficking in persons. I would only like to touch upon the Bali process that Indonesia is very much active over the last few years. And I think now is the time for us, for Indonesia, and for the government especially, to initiate another forum to create a regional consultative forum that has been firstly initiated by the Bali process, but it was already a long time not having a policy dialogue to deal with these questions that has been mentioned by my colleague, Pak Kadir. We thought further going to the different forums, I think what issues that have been mentioned also by Professor Widodo, we have been having many bilateral and regional cooperations and arrangements, but now is the political commitment of each country, especially those three that has been mentioned. Number one is the country of origin. Number two is the transit country, including Indonesia, and number three is destination country. Those three countries working with other countries at the regional level, including ASEAN, I think we need to find a solution in an arrangement which has been initiated from quite a long time. And Pak Widodo has mentioned also that Indonesia will host a very important summit. It is G20 Leader Summit to be held in Indonesia, in Jakarta. I would suggest to officials like Pak Kadir, government official, to take into consideration of having a certain agenda on the G20 and other highest political forum, so that these crimes against humanity, human trafficking and trafficking in person, is need to be abolished from the world, because the victims are almost children and women. And we have been experiencing many different cases experienced by Indonesia. I don't want to prolong the discussion up in the speech, but maybe it's better for me to look for another comments and discussions, because we still have one speaker from very far away from Munchen, Universitas University, Stephen Kors. We get Stephen Kors. Alles klar, alles good. Huh? Nice to meet you at this Zoom meeting, and of course we would like to have some input and suggestions from the perspective of lecturer at one of the university in Munchen in Germany. Bu Vera, I would be very pleased to give the floor back to you, and looking forward for other comments. Thank you once again.
Yeah, we thank you for your worthwhile information, Ambassador Professor Dr. Edi Pratomo. And then we move to the closing speaker. I call Professor Dr. Stephen Kors to deliver your presentation. The time is yours, Professor Kors.
Mohon maaf, Ibu Vera, bisa share screen saya?
Bisa,
Sendiri.
Profesor. Ya, nanti akan ada komite yang akan membantu.
Saya mau share, bisa?
Boleh, sebentar. Saya sampaikan pada komite.
Terima kasih. Ya, terima kasih banyak.
Yes.
Belum? Oh, mungkin.
No, I need to call.
Yeah.
Pak Lewi, can you help me, Pak Lewi or Pak Ria, to present the presentations of Professor Kors? Yeah, please, Professor.
Oke, terima kasih banyak.
Sama-sama.
Ya, terima kasih atas kesempatan ini, but I will speak in English because the presentation is too difficult for me in Indonesian language. Yeah, my view, thank you very much, Mr. Pratomo, for changing also to the issue of ubiquity. My presentation is very pessimistic about the future of the law in the digitalization. Well, my research is since 1996 on this ubiquity issue in the international law and in the conflict of law, and we have more and more the question how we make the statute decision in the conflict of law due to the internet ubiquity. Now, my thesis is that the law in the digitalization, the ongoing digitalization, may be replaced, and by replacement of the law, we talk about replacement of the human factor and replacement of the factor of trust, which is a basis from the law. And I would like to start with a citation of Lawrence Lessig, who already 2000 wrote about the West Coast Code and the East Coast Code. He means with the West Coast Code, the Silicon Valley, and with the East Coast Code, the legislation area of Washington. And in that time, he said there was no problem. There was a coexistence between these code givers, these law givers, as long as the West Coast Code was conducted by nerds But as soon as companies raised and the big concerns raised and took over the West Coast Code and the power of the West Coast Code, we really got a conflict. And this is more actual than ever in the moment because I have the impression that the factuality of the digitalization leads to the effect that this West Coast Code, the technology code, is winning. And we will have to think about how we control this. Now, the bow is coming from the internet ubiquity, which was indeed not really disruptive. I don't like the term disruption. It is also always used in every aspect, but in this aspect, I don't see much disruption by the internet ubiquity as we could handle mostly all issues, at least in the private law. Also in the internet, the contract law was not disrupted, the civil law was not really disrupted, but the ubiquity led to a disruption, and I would say even to a crisis of the international law, as the basis of the international law and of the law system, which is consisting of several national laws, is indeed disrupted due to the loss of the power of territoriality. Now this sovereignty approach that we have states which have sovereignty over their territory and of course have the legislation power over their territory is disrupted because the borders are not longer valid and the borders are not longer something which gives the states the power to keep out influences from abroad which they don't want in their society. Now this ubiquity is indeed this replacing the territoriality, and that led to the first problem, how we can apply state power, legislative power in our territories. Now we cannot actually, and so the pandemic was accelerating that even more, as you mentioned already, that we have a lot of new technologies. I would never thought about using Zoom video conferences, as I'm very conservative in my teaching and my lecturing, and honestly, I hate it. To sit in front of a monolith instead of standing in front of my students. And actually what we use in the moment is not really legally clear. For example, I'm actually not allowed to use Zoom video conferencing system, as we have in our university, we see a big data protection problem. And we don't have the safe harbor rule with the United States anymore. So actually I'm not allowed to use that. But nevertheless, we use that, and we can ask ourselves why we use that, why we don't care about legal respect to the law. The European Data Protection Regulation is clearly forbidding to use an instrument like Zoom, which is transferring data, personal data, to servers in the United States. Nevertheless, we do that. And why we do that? Because we have no choice. So we not comply with the law, and the law is accepting that in the moment. And this is the first aspect where the technology is displacing the respect of the law, because it forced the citizen to infringe the law, and the law is looking at it and cannot do anything against it because we have no choice. And of course, the rise of the digital platforms and the big data monopolists, which is not so interesting, and I want to let that out. Now, the loss of sovereignty due to the ubiquity of the digitalized world and of the internet, at least in big parts of the law. Of course, there are still territorial parts, but in big parts, especially in the business law and in the civil law, has four important aspects. First of all, if the legislation of the states have not longer the full power over the territory in certain aspects of the society and of the economy, then this will surely be followed on long term by a loss of the relevance of the law itself. Because due to this loss of power, the society will search for security measurements and security instruments which go over the legislative instrument and the law enforcement instruments. And we see this already with the technology of the blockchain, which gives us instruments to replace the problems of the ubiquity. For example, if we have the copyright law can be infringed worldwide, and yeah, of course we can apply our own national copyright law, but if we have the copyright tokenized and we use this tokenization, which is based in the blockchain, we have an ubiquity, sorry, this is not the right slide. I think you took over again. Is that possible? That you took over, but please, the next one. So I cannot share anymore now. The next one. I'm sorry, the next one. Yeah, and then the next one now, please. And this issue, using technology, which is maybe even infringing our interest in regulation, have also an economic factor, as we must think about whether we want to forbid it, how we want to limit it, and what happens if we limit it. I want to give you an example, please, the next slide. We see these augmented reality glasses, which are now developed. In the moment, they are very big and anyone can see when someone wears these glasses. But when these glasses are more developed, and then someone can wear it, it is all the time connected to the internet. The producers are maybe Xiaomi or other producers, maybe from the People's Republic of China, which have a different view on the data protection, on the human rights than us. And then anyone can scan anybody, what he does, and can have this moving data and send it directly to China. Now, of course, the legislation of the European Union or of Germany or of Indonesia could forbid to send data to China, but how to control that? This control is very difficult. So actually, the legislation and the states conducting has only two choices: or to allow it and not to control it, because the control is maybe just a lip service because it cannot effectively control, or to forbid it. Now, what would be the result of forbidding this? The result of forbidding it would be that we lose innovation power. So the European Union on long term cannot afford to lose the innovation power. Next slide, please. By forbidding a technology which is in the development. I'm not sure whether the legislation of the European Union is already aware of that fact. In the moment we see a clash between a legislative claim of control by the states and by the blocs and the reality of the ubiquitary society. This clash is because the legislation has not longer the power due to the ubiquity of this internet, which is also belonging and also applying to this technology like augmented reality glasses. Now, next slide, please. Now, why in a moment it still works in the international law? This is a very interesting political aspect, less a law aspect. If we see the data protection regulation, then the claim for regulation of the European Union indeed is still in power. We can observe that big data processing companies like Facebook indeed respect the data protection regulation of the European Union, but this is not so much because of the power or of the competence of the legislative power of the European Union, but more about the power of the economy and of the polity. Because Facebook or Google or these companies cannot afford to not be compliant with the European Union market. So the European Union is effectively, factually powerful enough to impose and to apply the law internationally. We could say extraterritorial, and this extraterritoriality is a problem of the international law itself, because extraterritoriality in fact is an infringement of the old idea of courtesy between the states. And of course, then also a problem of the territoriality principle to respect the territory of other countries. So we imply our law internationally, and the data protection regulation has extraterritorial aspects and extraterritorial rules. Now, is this really an infringement of the international law? Formally, yes, but in fact, we see here actually a sort of a self-defense of powerful states who has the power to impose and to apply the law extraterritorial to protect his citizens should do it. We see here the principle of the law of the strongest, but not because of regulation, but because of the factual situation of the technology of the ubiquity. Next slide, please. And this is indeed the crisis of the international law. Now, what choice we have in this issue of, for example, augmented reality and all these Internet of Things? We have the choice or to just close that out of our markets. Close it out is not an option because of the innovation strength. What is done can be done. And of course, United States and China will just do it. We know that. Or we have the choice to pragmatizing the law. And that is a little bit pessimistic. I don't say I like this approach, but this will be the approach which will be done effectually. We will pragmatize the law. For the example of the data protection, it means that we will make it free to the people to decide what they want to use and whether they want to take the risk that their data are transferred to abroad, to countries where not protected. And teach the people to be more responsible with the data, because the legislation and the state and the government could say, well, the people anyway share everything in the internet, so the people obviously don't want to be protected on that high level, and so let's lower the level, and then we don't have the problem of regulation. But this is a resignation of the law in front of the technology. Next slide, please. Next slide, yeah. Niklas Luhmann, a famous sociologist, said already, I think in 1994, talk about the lost power of the law. The lost trust in the law is leading to the longing for alternative safety. The breakout room will close in 53 seconds. Is that correct? I hope not.
No.
No.
Our seminar will end at 12 p.m.
Okay. The longing for alternative safety. Niklas Luhmann was not talking about the digitalization 5.0, of course, but Niklas Luhmann talked about the issue that if the law is not able to be enforced in a sufficient way to protect the citizens, then the legal system will strive to find another security system. And that security system today, in my opinion, is the technology, is the technological, issues and the technology instruments. Next slide, please.
Professor Kus and other participants, I apologize if in the organizations of this seminar there are shortcomings and errors in the presentations. Please continue, Professor Kus, to present your presentations. So you have a lot of time to present and to give our, your knowledge to us.
I will not overstretch it, don't worry. Thank you very much. That can happen. That is. Thank you very much. Now the next slide, please. Yeah. Where I was. The state sovereignty, which is lost, and the replacement of the law because of the loss of law enforcement will lead to the longing for different security measurements and security instruments which are in technology. I would like to give you 3 examples where the human factor is eliminated more and more from the law, and by technology already replacing the human factor and leading to a problem of social justice and of ethics. First example, very short, is an example from the antitrust law. We observed already influencing of artificial intelligence algorithms in the markets by observing market conditions and adapting prices algorithmically. Now, this was already a problem for the Bundeskartellamt. Lufthansa did that. And when the Bundeskartellamt was blaming Lufthansa for influencing the market in a forbidden way against the antitrust law, then Lufthansa answered that is not a question of the antitrust law because Lufthansa did not do it. The algorithm did it. The AI did it. Now, when we imagine that there could be an AI more developed, and then we have several of these algorithms interacting and collaborating in the markets and influencing markets, then we have to think about what will the antitrust law do out of that. Now, the antitrust law is based on the term of behavior, on market behavior. Market behavior, more or less, is behaving free, and AI cannot behave free. Now, if we have AI market influencing, it is very possible that we don't have the deeds, we don't have the legal rules for regulating that. We could, of course, just amend our law by certain aspects of this technological influencing of the market, but that would indeed eliminate a crucial aspect of the antitrust law and the behavior. Next slide, please. The second example, which is for me very important, and it shows also a problem for the ethic aspect and the constitutional basis of the law, is contracting by AI. We see already contracting more and more independent on human users. In a moment we don't have that, but it may be developed soon. Then we must think about how these contracts can be integrated into the law. Now, we cannot just take an analogy to the contractual law, to the law of the contractual intent and of the contracts, because the contractual intent is based on the prime principle of private autonomy. And the principle of private autonomy itself is based on the constitutional aspect of personal freedom of the legal subject. Now, of course, if we just say we make an analogy to the contractual intent in the contract law by AI, then we would leave this basis of the constitution in the freedom of the person. So contractual intent is not longer bound, it's not longer connected with freedom aspects and with the constitutional basis. And this is a very, very important step away from a humanistic basis of the civil law. Of course, there will be a new category of contractual actions, but indeed, this is maybe the first real disruption for the law by the development of technology, in this case of the AI, artificial intelligence. Next slide, please. Next slide. Yeah, this is the last example where, no, this one. Yeah, this is the last example where we can see that the human element in the law is replaced by technology. If we talk about a very actual topic in Indonesia is the hate speech and the fake news. We have that in Germany too. And in this case, we have a new regulation on the copyright law, which leads to the duty of the big platforms, namely YouTube, to filter any upload which could infringe the rights of others, especially the right of copyright. And this can be also applied to hate speech or can be applied to fake news. Now, if an algorithm, and that will be the consequence that these platforms will use algorithms to filter that. If an algorithm is filtering what can be uploaded, then we see that algorithms, that technology decide about free speech and free expression of speech. And that is indeed, I don't want to say that hate speech should not be eliminated, but this is indeed a systematic problem for the law, which shows that there is a conflict with the technology and the human rights. Next slide, please. Next slide. Yeah, what are now the consequences? Next slide, please. I hope that is the right. Yeah. One of the first consequence of all this is, in my opinion, that interpersonal trust will lose relevance in the law. That is very clear if we see smart contracts, algorithms which are executing automatically some interference of human beings, of people, then we can ask why we do this. This means we don't need the law enforcement, we don't need the courts to force someone, you don't need incentives to be contractual, loyal. So this is automatization. Of course, the legal conflicts will maybe shift to the part of the programming, but in the part of the executing of the contract, we have no human control anymore. We have automatism, determining automatism. Next slide. Then we see that trust in security and control by technology, so the blockchain technology, the smart contracts, as a consequence of the loss of trust in the state protection will take place. State protection, for example, or legal protection by state law, for example, in the copyright law, is no longer valid. We cannot trust that the state will protect us from infringements of our intellectual property rights once it is in the internet. So what can we do? We tokenize certain rights, we tokenize legal positions, and tokens are themselves, of course, ubiquity aspect and in the blockchain, but it is independent of state power. So the state power, the legislative power of the state is replaced by the technology safety, by the technology security, by blockchain ledgers, and also by smart contracting. So this is exactly the consequence which Niklas Luhmann foresaw in 1994. Next slide. Then automatization and determinism by AI, by smart contracts, will replace incentives for compliance and of law enforcement. We don't need these incentives in many cases anymore because there is automatic execution of certain actions. Without that, someone must comply with the law. Next slide. And finally, we will see a certain loss of the constitutional basis of the private law by abandoning the freedom concept of the private autonomy, which is very dangerous indeed, because this also is leading to a loss of the equilibrium and the valuing in the law, maybe by replaced by determined utilitaristic programming, which is rather bound to effectiveness and less on the protection of the weaker. Next one. The consequence is we have determinism contra emotional flexibility. This is indeed a moral problem, an ethic problem. The European Union sees this problem, and we are now discussing about a new legislation on a human-centric artificial intelligence. Whether that approach will work is not sure, because we will see that until now, since 1994, we discussed about Lessig's thesis about the West Coast law and the force in the West Coast, the moral and the ethic and the valuing and the social justice. We can, in a moment, still force the programmer to integrate it in a certain way in the programming of the AI, but the more independent the AI is, the less we will be able to do that, because the programmer themselves have not the influence on the AI. So where is the moral and where is the ethic in the law? In the future, if we have a technological effectively a technological execution of the law. Then determinism instead of normatism, this is what I mentioned. We have not so much valuing anymore. We have determinized actions by technology, which can be in a certain way programmed, also can be in a certain way programmed to utilitaristic goals, but not so much in the way of flexibility of the human decision. And very important idea of my colleague Shidata from BINUS, the utilitarism instead of other ethic concepts, for example, equality, justice, freedom. How an AI want to value that? And this is something we discussed already long when we see the integration of the economic analysis of law in Germany. When we discuss that, I come from a school which is rejecting the economic analysis of law as a dominant instrument for evaluating the law. We see that the business law must be socially responsible. So there is responsibility, the more power you have, and that must be integrated itself in the law. This is the totally contrary on calculatable law decisions, which is the idea of the economic analysis of law and which can be programmed. And this is also an issue for Indonesia, as here this corporate social responsibility is very much discussed, and the social principle is a very important aspect in Indonesia, also for other states. In Germany, we have it even in our constitution. The next slide, please. I would like to finish with a question: which will be the role and the justice in the future if this development takes place? And honestly, I'm not sure. Honestly, I don't see many ways to integrate the ethic and the justice if we have full automatical executed legal actions, legal in this alternative sense. Next slide. I want to give you, just for the end, two citations. One is from Margarete Vestager, European Commissioner for Competition, when she was presenting the new draft for the human-centric artificial intelligence. She said, on artificial intelligence, trust is a must. See, here we have the trust, not a nice to have. With these landmark rules, the EU is spearheading the development of new global norms to make sure AI can be trusted. This is a nice goal, and I agree with that, but I don't agree with this optimistic view. In the moment, as I said, we can handle that with certain rules but on the long term, I'm very pessimistic on that this legislation will be valid enough and will be strong enough to protect us from independent technology. Next slide. And finally, this is the citation of 1975 of Mr. Joseph Weizenbaum, a German scientist, computer scientist who emigrated 1936 from Germany. And he said in his book from 1975, Computer Power and Human Reason, already, I argue for the rational use of science and technology, not for its mystification, let alone its abandonment. I urge the introduction of ethical thought into science planning. I combat the imperialism of instrumental reason, not the reason itself. This is optimistic and pessimistic in itself. Yeah, so he says we need ethical thought in the science. In the science, we will be able to integrate it, but will we be able to integrate it in the technology itself? In 1975, he already foresaw the main problem, the integration of the ethical thought into the programming. And if the self-programming takes place, I'm very pessimistic that that will be longer possible. So my view is not very bright. Next slide. I will elaborate that in a journal article, which is in preparation, will be soon ready. And then I hope you can go more into the deep. This is a very short time for me. I don't want to make it more longer. My ideas, I think, are clear on that. And you'll find in the next slide, next slide, please. You'll find the references in your materials, which will be sent to you by the committee. I wrote certain articles on the artificial intelligence as judges in Malaysian Journal of Sharia and Law, and then two articles in Indonesian journals on this disruptive effect. I thank you very much. Terima kasih banyak atas perhatian Anda. Saya selesai. Terima kasih.
Jadi aku bawa cara ganti, terus disuruh tes darah sama barium.
Ladies and gentlemen, please unmute your speaker. Thank you. We thank you for your fruitful information. Now we enter the question and answer sessions. I invite viewers to pose questions to our speakers. Please raise your hands and unmute your speaker. The moderator will please you to speak. there is one person from Wasis Susetio. Please, Mr. Wasis Susetio, you can unmute your speaker and then,
okay.
Yeah.
Yeah. Okay. Can you hear me?
Yes, please.
Already. Thanks for the moderator. And then actually my question addressed to Professor Dr. Edi Praptomo first. And the second one for Professor Kos. Yeah. First question related to your presentation. That's a very interesting presentation. And then I'm interested to ask you about the future of our curriculum, especially in particular, facing for the digitalization, and then also criminal in internet. Actually, I'm inspired by the book. Title of that book is maybe this is very popular. Yeah? The Future Crimes by Mark Goodman. And if we read that book, yeah, actually there's a lot of something. Maybe, yeah, it must be anticipated with our curriculum. Because this is very sophisticated criminal, so I think maybe we should change our conventional curriculum to the future curriculum to anticipate it. So, is there any idea or opinion from Professor Edi actually for the criminal law? Yeah, to anticipate that the issues of criminal in the future. That's the first one. And the second one, my question addressed to Professor Kos. Yeah, this very amazing presentation. I think this kind of lecture. Yeah, I just got the first one. Yeah, because this issue is very important to us. Yeah, especially for the AI. Yeah, regarding to the AI, in particular the responsibility AI in the contract. Yeah, I'd like to know about how to distinguish between. Yeah, sometimes we maybe in the future, yeah, we make the contract through the internet only. I mean, just making the contract through the internet, yeah, or even the application, yeah. But maybe some respond, yeah. Just AI product, yeah, but how to distinguish between the product by man or and then with the AI product? Is there any maybe like a tracer machine or something like that? And also, yeah. Related to the responsibility of AI, right now, I don't know, yeah, but some reference talk that there is the process of making the AI product, yeah, made by the machine who operated by AI. So what I mean is, yeah, the product itself made not by a human, but AI. So if the second layer of such a machine, how to put the responsibility to to ask the responsible for that kind of machine. I hope that you get my point, Professor Kos. Thank you.
Yeah, we have taken note of Bapak Wasis.
Yes.
Thank you very much.
Yeah, all right. Thank you.
And then for the next person, Ibu Dewi Tenti, please deliver your question. Could you please unmute your speaker, Ibu Dewi?
Yes.
Thank you very much.
Terima kasih Ibu Moderator atas waktunya. I would like to ask to Professor Kus also. Thanks for the presentation, Professor. My name is Dewi from Jakarta. My question is, does digital transformation immediately change the function of the legal profession, which is currently more of a soft skill? Because the profession, there's a human of trust, like you say, humanity, not a robot, especially in Indonesia, because data protection, in Indonesia is not a guarantee. It will more difficult to know whether it's person behind the transaction is really human. Thank you very much.
Yeah, and then the next questions in Pak Raditya. Pak Raditya jadi mau bertanya? Mr. Raditya, last minute I saw your Mr. Gusta Ferisa. Am I correct?
Yes. Hello, everybody. Good afternoon.
Yeah.
I'm Gustav Fariza from Law Faculty of Esa Unggul University. Thank you for my chance to be questioned to the Mr. Kos. I'm interested with your presentation, and my question is the changing climate of the contract should be many impacts in implementation. So how to prevent the fraud of the contract by IA? Because as we know, there's some country in the world not prepared yet about the regulation, especially for the forum. Yeah, just a forum if there's any break of contract regarding from the AA. That's my question. Thank you.
Yeah, I think for the first sessions of answer and questions, I will only close for the 3 presenters. So I will give you the floor, Professor Eddie. Please, may you answer the question from Bapak Wasis.
Yes, Bu Eva.
Yeah.
Question from Pak Wasis is quite relevant to our changing our mind. And that's why I was suggesting that now the faculty of law everywhere in the world need to review the current and existing curriculum, because now the challenges and opportunities are quite large. It is evident that what has already been expressed and put forward by Professor Kos of Germany. Now he is visitor to BINUS University. Cybercrime law has been added to the curriculum at the Faculty of Law, but it is not yet fulfilled in a very good approach. That's why we need to invite in the future all alumni and the user of the law graduates. We need to have a discussion with our partners, foreign partners, and also internal partner, national partner, to discuss what that has been missing in our curriculum, because the challenges is so sophisticated and they are very professional. Professor Stephen Coles just mentioned, it is quite, very professional criminal act that is now being initiated by certain quarters, and the involvement of government and state is very important. We thought further collaboration between governments and stakeholders, I think we cannot have the very comprehensive curriculum that may respond to the challenges. Yeah. Now the Ministry of Education of Indonesia has introducing what they call Kampus Merdeka, the independent campus program. And under this program, we are advised to change. We are advised to review our curriculum, especially at the Faculty of Law that I was suggesting in my presentations, because the challenging are so big, and the development of law need to be, taken into consideration, especially because now the world is facing with many challenges. There are so many mafias, many certain quarters are using the internet professional information technology base, and we sometimes, the law graduates, could not deal with these questions. So the involvement of the government is very important, and we need to have certain international standards, certain international regulation that are accommodating the challenges. We need to have a certain agreements, especially in dealing with this question that we are now facing. Thank you.
Yeah, and then the next, Professor Kus, please, could you explain the question?
Terima kasih, Bapak Wasis. Actually, we know each other from long time ago. I think 2009 or 10 or something like that.
Right. Yeah.
I remember your father. Yeah, thank you for this question. Maybe you allow me just to also refer to Bapak Edi Pratomo, because I agree very much. We made an accreditation of a university in Indonesia now, and we found the curricula quite static, which we have in a moment, quite static, quite in small aspects, one small aspect after one small aspect, not so much approach. And I think very important is not only the interdisciplinarity with the technology and the economy in the law, but also to strengthen even more the idea of ethic and the feeling of ethic, especially in this world. We must have ethical, well-thinking people who are able to understand when there is an ethic problem and when not, and not only utilitaristic. So now we come to the question of Bapak Wasis. In this, what you mentioned in your question, and also more or less the other questions come to that area, to that point, is a question of responsibility, transparency question. The transparency aspect is something we have already in the consumer protection in the moment, as we have the algorithmic pricing, and the algorithmic pricing, which is based on profiling in the combination with big data. Companies know everything, our moves, anything. You see this augmented reality and all this Internet of things, and then they sell this data and these profiles to companies like Alibaba or Amazon, and then they know how we are willing to pay for something and give us a price. These aspects are aspects of the consumer protection, especially of the competition law aspect of the consumer protection. Also, we see the algorithmic pricing in the antitrust law. And in the moment, we are not able to say what is forbidden here. This is very interesting, especially in the antitrust law. We cannot say why algorithmic pricing is a problem of the antitrust law, because as I mentioned, there is no behavior. And so here in the moment, we would say the approach to regulate this behavior in the antitrust law and in the competition and in the consumer protection law would be to link it with the speed and with the transparency. So we must say that, of course, price adaptations done by human is not forbidden. And also not individual prices. This is freedom of contract. But if artificial intelligence does it, then the principle of the weapon equality is switched off. So the human user is not as strong as the artificial intelligence, which he not even sees. So we have the issue of the transparency, and we have the issue of the speed, and we must decide, and that can only be in an interdisciplinary approach with the economy and the technology. We must decide how we formulate these forbidden actions by this. And now we come to how we can handle that. Actually, we cannot know. The user cannot know. The consumer in the moment cannot know whether there is an AI or there is a human being. We have experiments which show that AI can already write news text, which are very authentic, and then they give this text to people and they read that, and they would not able to differentiate whether that AI was writing that or a human being. So they can write stories, yeah, and it will be more and more independent, and then the transparency is even less. To think about responsibility rules which assign responsibility even without culpability and even without influencing ability to certain entities or to the entity itself. The AI could be personalized. Then the European Union already discussed about an electronic person. So the electronic person would be a legal subject. The legal subject would be responsible and can be sued. Problem will be more in the tort law that we need then also a substrate for suing. The legal entity needs money for paying the penalty or for paying the damage repair. And because we have a legal person, which is an e-person, we don't have someone who can pay. So who pays that? There could be funding systems by programmers, by companies who sell these or use these, something like that. This is, of course, utopia. Or we assign responsibilities to the user or to the one who is having the success from the use of the AI. So if someone uses a dangerous instrument which gives him in profit, then he must be responsible, whether he can influence it and how he influences it or not. Yeah, this is very clear. If I use a car in the traffic, then in German law, I pay. I will be sued for any accident which occurs with that car, even if I'm not culpable of the accident, because I use an instrument which is dangerous for the society, and the danger for the social danger is an aspect to assign responsibilities and assign risks to the one who is using the dangerous instrument for his own profit. And this is an approach we can in a moment do, but the more independent AI will be, the less reason we have to assign this risk to someone. Imagine we have already artificial intelligence, or we have smart contracts which are totally independent of users. They just act totally independently. So who is to be assigned then for the responsibility if the AI is totally independent? Or can we really assign the responsibility of using a car which is self-driving and deciding whether it should collide with the grandma in the street corner or with the wall to protect the driver? Can we really assign the responsibility to the human being who is using the car if the law forces anybody to use an AI independent car? In a moment, we are not forced to use that, but you know that, look, the traffic in Jakarta, you have a lot of cows. Now imagine you have self-driving cars in Jakarta colliding with these cows of the human being in the cars. So what will be long-term happen? On long-term, we will forbid the self-driving and we'll have only AI conducted traffic systems and self-driving cars. And then I don't have the choice to use this technology. So why should be the risk assigned to me as an individual using this technology? Then we have social costs, which must be assigned to the to the society itself. So this transparency problem is there. In the moment, we have just helping approaches like. So if green, then it's not so dangerous. If yellow, a little bit more. If red, be careful and better ask. Yeah, but if that is done by China, how Germany will or European Union will do that? Yeah, so how we can do it? This is, and the approach of the European Union is a level system. So European Union is defining certain aspects where AI could be used and defining whether that aspect is dangerous for the society or less dangerous. So if less dangerous, it's very liberal. You can do whatever you want. If it's very dangerous for the people, so the AI decides about the fate of someone or decides about life and death, imagine in the hospital about deciding whether the breathing machine should be on or off or how to make the surgery, then the AI is very much restricted and the responsibility very strongly given to the one who uses that. Whether that will be on long-term work is not very clear. It is in a moment only workable for the weak AI. For the strong AI, maybe we need a new approach. Now to the question of Ibu Dewi, the soft skills and the legal profession. The legal profession is indeed already influenced by the AI. My approach is that it is in any case not compatible with the human dignity, for example, to use AI in courts. Of course, not as courts itself or as judges itself. Why? Because because if AI is not faulty, AI is determined. AI is logical, and of course it could be programmed wrong, but normally it acts exactly what it is determined for, what it is programmed for. Now, if we see a delinquent in front of a judge, what is the situation of this delinquent in front of a judge? Now, I was myself a criminal judge. I had bad days, I had good days. I had days where I had to wake up in the night and was very sleepy, and then maybe I was making mistakes. Because we are faulty human beings. Now, these mistakes are the chance for the delinquent, because the delinquent could be maybe more mild sentence, or it is also a bad fate for the delinquent, because the judge could have a bad day and say, okay, I take the higher range of the penalty for this delinquent. Now, this is faultiness, and many people say, let's replace the legal science, the legal profession, especially the courts and the judges, with AI to eliminate this risk of the human faultiness. But this is indeed a problem with the human dignity, because every human has the right to be judged by a human being and to be evaluated by a human being and not by determined AI. So I think in any case, the government and the states cannot, at least not in constitutional government, cannot accept the influencing of AI in the legal profession. And you mentioned the soft skills, you mentioned feelings, you mentioned emotion. This is, of course, also a question of a dialectic and of the communication between the lawyer and the client, or between the judge and the delinquent. This is a question of human dignity, and this is exactly what I mentioned. And let me just finish with one hint. There can be expert systems using AI. For the advocates and for the notary, I would not have too much problem with using AI systems who are making some idea about what can be the outcome, calculating something or whatever. But in the courts, I think also we must always take care of the biasing of the courts and of the judge. If judges use AI systems to evaluate proof and evaluate facts, and then it gives you a certain idea about to 90% it is like this or 90% is not like this, then the judge will be biased, and that itself will be a problem of the ethic and then of the constitutional basis. And you all know the human dignity is unalienable. Now the last question, Mr. Gusta, the break of the contracts from the AI. the break of the contract from the AI cannot be handled in a moment, and it is not necessary in the moment to handle that, because in the moment we have no strong AI. So in a moment we can say whatever AIs do, also in the contracting, is more like vending machines. So there is always some human being behind it, giving anticipated declarations of will to the system, and then the system will execute that. It's nothing else than if we have vending machines at all. Yeah. So in the moment, this is not a problem. Probably the problem is in the copyright law. Is there a copyright of AI made pictures or music or so? Yeah, you all know this issue with that monkey from the Borneo forest who was having this law court in the United States, whether the monkey has a copyright of the photo of the selfie he did in the forest. This is the same issue. Of course, the monkey cannot have that. So the AI, and then we can always assign the copyright to someone behind that. This is in the moment the case in the AI, so no problem. But once the AI is really independent, we must think about that. And then we don't have a solution about this breach of contract. This is why I say we cannot just make an analogy from the contract law we have in the moment to the AI contract law. We need a totally new contract law of the AIs. And then we must also think about what is in breach of trust, whom to be assigned the risk of breach of trust, whom to be assigned the risk of wrong programming, because smart contracts can be programmed wrong. I mentioned that the trouble is not in the execution of the contract, but is in the program of the contract. So the responsibility of the programmers come into the foreground. And this cannot be answered in a moment. That will be elaboration. And I'm also very pessimistic on that, also on the legal education. Because we know that always does like this. When we talk about genetic issues, about cloning, we discussed already 30 years before about what is when cloning comes. Now cloning is there and we have no answer about that. Yeah? And what can be done will be done. If it can be done, then the Israeli, the Chinese, the US will do it. For example, we have legislation about AI should not drive independent without the driver that has an influence. And the United States did not sign this Vienna Convention on individual traffic and this AI amendment. So they will do it. And once they do it, they will sell it to the world. And once it is sold in the world market, it is coming to us. So we need the answers now. The law should not all the time run behind the technology. It should be step with the technology. And for that, we need a legal science which discuss that and are ready. When I discuss these issues with my students, they like it, of course, because they think, oh, this is something very placative and very colorful, nice idea. Yeah, they like science fiction and all that. But it is not science fiction. It is, of course, utopia. But we must discuss about these ethical and constructural issues before the technology is there. That because of that it will come. That is very sure. I think this is answering more or less all the questions. Thank you very much.
Vera?
Yeah.
Can I pose a question to Professor Kus, please?
Yes, please.
Okay, thank you, Vera, for giving me the floor. Thank you, Professor, for your thought-provoking presentation. You know, I learned a lot of things. It's a very interesting presentation. I think you specifically mentioned on the consequences of ubiquity is the loss of value and ethic in law as it has been replaced by automatization. My question is how it can be the case as we know that the algorithm is created by humans. The AI would work on certain logic which have been determined by the creator of the algorithm, despite the unlimited capacity of self-learning of the machine. Do you think the value or ethic embraced by the creator of the AI will influence the work of the algorithm? If yes, how can we say that the machine is free from value or ethic? Thank you.
In a moment, yes. In a moment, it may still be the case. And that's why in the moment, and that is already a little bit behind the future development, in a moment we just discussed why the law did not yet have rules how to make the programmer responsible for integrating the ethic into the programming. So it was already discussed since Lessig was bringing out his book in 2000, because it says the East Coast code should not resignate to the West Coast code. This means force Silicon Valley to integrate the ATIC. In a moment, it may be possible, even if it is not consequently done, but it is possible, constructive, from systematic. But the more independent this AI will be from the programmer give it someone mentioned that the programmer give it the capacity to self-learning, to self-producing. As my colleague said, there will be 2 levels or 3 levels, and the AI is developing difficult. And then there can be rules, and this is really the pure science fiction. If you read Isaac Asimov, it's very old, and he talked about this these robot laws, and the robot laws giving the robot the undiscussable and undisputable duty to always, in any case, respect human life. Now, this in the science fiction is very easy to say that respect human life, and you can also give it rules to respect ethic, but ethic, as you know, is already a very flexible concept. And that is why I think AI will never be able to be a judge, because AI will be never able to apply ethic to the society. And just an example how we have a conflict between these technological guys and the legal guys, at least the legal guys who are interested in the ethic. I was some years ago in a conference in Addis Ababa, and there was a Finnish colleague from Finnish University, and he said, Stefan, I'm so sorry, yeah, but your judges and your lawyers and your law experts, you will be replaced soon. We have already so good expert systems. We have already so good AI. It will be replacing the judges in the future. And even if we take away this constitutional basis of the human dignity, which is a thesis of mine, which is maybe not anyone will agree with that, even if we take that apart, then you all know that legal application is more than just apply the words of the law. There is always a flexibility. There are reduction to zeros because of certain aspects or certain social conditions. We see this reduction to zero now as the Zoom is forbidden, but we use it. And why we use it? Of course, there is data protection regulator in Germany trying to sue the teachers in our schools in Berlin. He did it because using the Zoom in the pandemic, because what should they do to teach the children? And then this data protection commissioner said, oh, this is infringement of the law. We will sue you. You will have to pay a penalty. This is a scandal, right? And I could do that. AI could do that. But if we make a reasonable law, then we must always take care that there is also reduction to zero of certain law in certain social conditions. And we must infringe the law formally to get justice. How should ever an AI do that? So this is the second part of my answer. In the moment, yes, we can, even if it's maybe not enforced everywhere. In the future, I don't see how we integrate the ethic in this way, in the flexible concept. And then think of the ubiquity again. What is the ethic in the People's Republic of China? I don't want to judge that. This is just a different kind of view. What is the ethic in Aceh compared to the ethic in Java? What is the ethic in Germany compared to the ethic in the United States in the Trump government? And so on and so on. You see, when we talk about ethic, we must define first what is ethic. That is why I don't like the word moral in the law so much, because moral is really a totally flexible and individual concept. Is there really a world ethic? Yeah, and if you talk about local values or traditional values, which is this adat relation to the state law in Indonesia, you yourself discuss about what is the value in your law and what is the local value, and what is the acquis communautaire of the local value in Indonesia. Is it what is really adat? And we see in part of Indonesia that there is always this reclaim of adat, and actually this protectionism, because nobody really says this is really adat, but it is just protection of local companies. Is this really adat? So how a machine can value what is really traditional value, what is ethic, and how this ethic should be equilibrated in the world ethic or in the relation to the ethic of other countries in the ubiquitary world.
Thank you.
Thank you, Professor Kus. So I think the time has approached almost 12 p.m. We need to move on the next session. Please allow us to end this seminar with a brief conclusion. Technology is a great opportunity for humans to simplify all human activities, especially during pandemic COVID-19. However, nations need to adopt law to regulate it and protect the citizen rights. So at the end of the seminar on facing the challenge and opportunity to the legal discipline and profession for the next decade, on behalf of all committee, we would like to thank you for your participation in attending the seminar. I apologize if in the organizations of this seminar, there are shortcomings and errors in presentation and slip of the tongue. Finally, we express our gratitude by praying Assalamualaikum warahmatullahi wabarakatuh, creating healthy, prosperous for all of us. See you in the next time. The times I delivered to the committee, Ibu Nabila and Mr. Lewi.
Thank you, Ibu Vera.
Yeah.
I would like to say thank you to the speakers and moderator for the very interesting presentation and question and answer session that we had. Please give big virtual applause to the speakers and moderator by click the applause button on your Zoom meeting screen. So to all the participants, I would like to inform you to not forget to fulfill the attendance, which the link had been shared in the chat box. Thank you. Ladies and gentlemen, we finally come to the end of the event today. As the master of ceremony, I'd like to sincerely express my appreciation for this opportunity to presenting this event. And on behalf of the committee, I would like to say thank you not only to the speakers and moderator, but also to the audience entirely. May what we had conducted will be useful for all of us. From the deepest of my heart, I do apologize for all mistakes in presenting this event. Thank you very much for your kind attention. See you on the next event. Wassalamualaikum warahmatullahi wabarakatuh. Shalom, Om Santi, Santi, Santi Om, Namo Buddhaya.
Thank you very much. Thank you to to the other speakers, Mr. Edi Prato and Mr.
Thank you, Stephen. Thank you, Pak
Thank
Kadir.
you.
Pleasure.
Thank you, Pak Edi. Thank you, Professor Kus. It's very nice to see you. Bye-bye.
Bye-bye.
Terima kasih, Pak Edi.
Terima kasih.
Terima kasih, Bu Nala.
Vera.
Sama-sama, Prof.
Ya, silakan.
Prof Edi, mantap, Prof Edi.
Aduh, apa kabar ini? Ada muncul di sini.
Sehat ya, Prof Edi?
Alhamdulillah sehat, Pak. Apa kabar?
Kapan kita makan lagi ya, Prof ya?
Ayo dong.